Good morning, everybody. It's nice to see all of you here in the morning on a weekday. We are actually celebrating the enactment of the Copyright Act, which was done 10 years after independence on 1957.
What option is out? Now it is, yeah.
So
Yeah.
we are on the 67th year of this
Okay.
act, and this is kind of small celebration to remember the enactment of the act. So we have a small session today, which we have named Demystifying Copyright, and where we have got an excellent speaker. To start today's event, I would first call upon and request our honorable and respectable Vice Chancellor, Sir Professor Sri Krishnadeva Rao, to give his opening remarks.
Good morning, all friends. Professor Anandya Sarkar, the IPR Chair of Nalsar University. Dr. Raghavendra, old friend, and happy to see Dr. Raghavendra today as the main panelist, former Joint Secretary, former Registrar Copyright, Ministry of Law and Justice, friends, and all those who are interested in protecting and promoting copyright in specific and IPR in general. Copyright plays a very important role in communication and promotes progress of society. In fact, the original ancient, the oldest form of IPR is copyright, particularly in the higher education or education in general. The copyright believes in dissemination of knowledge and also protecting the rights of the authors. We know when the printing press started, the whole part of publication of the books and authors have emerged as an important stakeholder in the dissemination of knowledge and also to promote more ideas, expressions, and thinking. The idea expression dichotomy, all of you are aware, is very crucial in the copyright. And with the technology, copyright has changed leaps and bounds. And so today's webinar on copyright comes at a time when the intellectual property landscape is evolving rapidly, driven by advancement in technology and ever-growing importance of creativity and innovation in our society. As I said, copyright is a critical aspect of intellectual property, which plays a very vital role in fostering creativity, protecting rights of creators, and stimulating economic growth. Professor Anandya Sarkar always cautions and reminds us that intellectual property is very crucial, not only in promoting innovation, creativity, but also economic growth and prosperity, development of the society. Intellectual property has played a major role and contributes to development. And intellectual property is also an integral part of business strategy in the modern world, as companies increasingly realize the value in their intangible assets. So therefore, intellectual property is not just a legal concept, but also a powerful tool for business to gain a competitive advantage, protect their innovation and general revenue. In today's rapidly evolving technological landscape, business that neglects the importance of intellectual property, they have a risk of being left behind. As a leading national law school in India, the intellectual property chair, Nalsar, regularly organizes some of these discussions and panel discussions. I am happy and glad that IPR chair under the leadership of Professor Anandya Sarkar taken this important aspect and demystifying copyright. We always used to say demystifying is a very important segment of the legal knowledge. because otherwise legal knowledge will become monopolized. So copyright is very important in this aspect. We are looking at how to demystify, how to create an awareness, and also at the same time protecting the literary works, artistic works, musical works, dramatic works, and also technology has it, also the computers and some other aspects of computers are also now can be capable of getting the copyright protection. In this era of digitalization, once again, importance of copyright has to be re-emphasized. Globalization and digitalization has really, it's a crucial to have a deeper understanding of copyright principles, both from a legal and practical standpoint. The objective of this webinar is to demystify the complexities surrounding copyright and provide valuable insights into its interpretation, application, and enforcement. And we have also seen the judiciary courts have played a very vital role. We look at the Delhi High Court's contribution and other high courts also. You see, wherever there is some gap in the interpretation of the law, the courts are in the forefront, and that clearly gives a clear picture of the interpretation of this. Through this webinar, we aim to bring together experts, practitioners, and academics to deliberate on key aspects of copyright law, including protection of literary, artistic, musical, and dramatic works and other creative works, the scope of copyright infringement, fair use. I really like one of the public interest provision in the Copyright Act is the fair use. In fact, as a law teacher, I would encourage more and more liberal interpretation of the fair use, particularly not for commodification of the property, but the public dissemination of the knowledge. So fair use, licensing, and there are challenges which are posed by the digital technologies. So therefore, I once again welcome all of you to this webinar, and we look forward to more engaging and fascinating discussions and debates. Once again, we are grateful to Dr. Raghavendra for accepting our invitation to be the main panelist in this webinar. Thank you. Thank you.
Thank you very much, sir. We will try to emphasize and look into the points which you have mentioned in today's discussion. See, at this moment, I would like to also mention that, Nalsar, with the leadership of, Professor Krishna Rao.
Voice is not clear.
So I would like to make one point here that, our Honorable VC sir has been very encouraging in all IP activities and has been a steering force in helping us have such events at regular intervals. So now my turn to welcome Dr. Raghavendra, a very good friend for last over 2 decades now. If I want to introduce Dr. Raghavendra with copyright, that is a very complex situation. In the Indian scenario, Dr. Raghavendra is synonymous with copyright. He has not only been the former registrar of copyright, he has played a very important and pivotal role in this area in many ways. See, he has been part of WIPO treaties. He has contributed to the copyright laws of several countries. He was part of the FTA negotiations. So this is a big, big list. And I'm very thankful to him that he could really find out time to join us today. I know you are going for the roundtable to Japan tomorrow or today evening. Somehow we could, you were nice enough to accommodate us. And also congratulations for your, recent PhD, which the convocation was held, I think, day before yesterday. So with that, we would like to have some areas to look into, some things to so that it becomes very clear. Dr. Raghavendra, see, we have participants from various backgrounds with more than 500 registered participants. I think, you can first set the tone is that, what is copyright? What kind of works are protected? And what is the core aim, that copyright seeks to fulfill?
Um, Thank you very much. Hare Srinivasa Vande Mataram. And I would like to thank my two friends, Professor Krishnadeva Rao Garu. I know him for the past so many years during his NLU Cuttack times to NLU Delhi and all that. And my co-resource person in Nalsar earlier and now IPR chair head of DPIIT, Dr. Anindya Sarkar, and another good friend of mine. So it's just like homecoming to me, sitting in Nalsar campus and then moving around and having fun and teaching students. And it's a great opportunity to me, and happy to see many faculty of the Nalsar and researchers, students, not only from the Nalsar various places they are logged in. So, Endaro Mahanubhavulu, Andariki Vandanamulu. So, let us begin to demystifying this copyright. Actually, this initiative has been taken by my friend Dr. Anindya because DPIIT is celebrating this 2 weeks long festival of enactment of Indian Copyright Act 1957, way back 4th June in 1957. So, it went on, various IP chairs, universities celebrating, and it finally hopefully conclude with the 22nd of June when the amendment to the Copyright Act 2012 was enacted. So the topic chosen by Nalsar and Dr. Anindya is very interesting, especially this new emerging disruptive technologies like artificial intelligence, blockchains, metaverse, NFT, the new technologies are coming, like quantum computing and the Web 3.0 is knocking our doors. So everything going to be decentralized. But there are some myths. We need to demystify this. If you get into this kind of web, you get confused. So let us start why DPIIT started this 4th June festival, and 67th anniversary of this enactment of the Copyright Act. No, actually, post-independent, we introduced our own Copyright Act 1957, but it was British who introduced Copyright Act in India. 1847, the UK Copyright Act, they introduced here. But before British government thought of that, one court case in Mumbai High Court at that time made Mumbai High Court to take a decision in Macmillan versus Khan Bahadur Shamsher Jaka. Is a copyright infringement, a piracy of Macmillan books they were fighting for. So they could not apply any copyright protection for Macmillan because there's no act at the time. There was no act in that time. So then judge decided that British Act is applicable because our is a colony of British island. So that way it was implemented here. And later, in 1847, the British Acts of 1842 was implemented in 1847, and they came out with the new Copyright Act in 1911. That is UK Copyright Act, Imperial Copyright Act. That was introduced in India in 1914, the first comprehensive Indian Copyright Act. But post-independent, after India became the member of Berne Convention, and many things happened. The technology changes were happening, and new international conventions came after Berne Convention for protection of the literary and artistic works of authors in 1886, the first convention. Then 7 times it had been amended. In 67, India wanted a reproduction exceptions to this reproduction right, exception to translation, and also compulsory license, because the entire publishing industry was concentrated in the European country. India wanted compulsory license for translation and publication, uh, for the access to information and knowledge for its educational sector. And then came the internet. Sorry, before internet came, the Berne Convention did not address the issues of rights of performers, rights of phonograph companies, that is music companies, and also the rights of broadcasting organizations. So they needed a new treaty in 1960. They come out with the Rome Convention. Then technology started disturbing these music companies' survival with the music piracy. So the phonogram piracy was a big thing. You know, those times tape recorders were the small cassettes that can be copied and sold. That's where the famous T series birth took place in India with that piracy, and then now they became the leading music industry copyright holders. And then Geneva Convention came in 1971. India is one of the first countries to sign and ratify, because Indian music industry is so robust that it wanted to protect its the various stakeholders. And then came another technology, that is broadcasting technology was spreading. You know how it started. It is a terrestrial broadcasting. Those remember the Doordarshan channel. We used to have a high power transmitter, low power transmitter. We have to push the antenna in that direction so that we can get the clear feed. But later technology introduced the satellite broadcasting. Then there are unscrupulous people. They used to steal the signal of that satellite, and before reaches to your television screen, they used to put it through the cable operator by jamming the main Doordarshan channel or any other right owner. So there was a treaty needed. But while finalizing the treaty in the Brussels Conventions, they call it, 1974, a historical mistake was done by the negotiator. Nowadays we have all the DTH, direct to home technology, but it was there already in the early 70s in Europe, and it spread into various countries. But these people thought, developing countries, least developing countries, even in India, direct to home started somewhere. I remember when I went to the Hague, Netherlands, for my public policy post graduation. Everywhere DTH was there, and India hardly it made entry in 2004. So we didn't give a damn, and developed country also didn't give a damn. So that became a debt treaty. Now we are fighting for a broadcasting treaty in the WIPO SCCR, where we want to control unauthorized distribution of signals over the internet, unauthorized streaming, because the web streaming rights are different from the broadcasting rights. Which what you see, you must have seen recently, IPL 23 matches where our hero Dhoni had won the IPL 23 championship. Broadcasting rights separately given to television channels. Broadcasting rights are separately given to streaming. Earlier used to be Hotstar, and nowadays some other streaming web channel has got that. So separate rights are there. So what are these rights then? Then internet came. WIPO introduced WIPO Copyright Treaty to extend the rights given to authors and also the performers in the WIPO Performers and Phonograms Treaty. So all the rights for in the physical world for the books and artistic works and music and dramatic works and singing, the performances and music industry extended, because everything through internet nowadays. And then the Beijing Treaty came, where audiovisual performances also treaty was needed. Then came the Marrakesh Treaty, where we negotiated in the name of human rights to giving the first copyright exceptions treaty for our visually impaired and the physically disabled brothers, Divyang brothers, so that they can access to these published works not only through the braille uh, format, Now, all these specially formatted software formats are made available. So there is no need to take a license by them. They can do conversion or next of the kin, or Nalsar can do conversion, even though it is commercially available in the market. You walk into bookshop, buy any latest book on the law. But unfortunately, our visually impaired brother or a sister can't go to the bookshop and buy it. So a talking book has to be made available, which normally the publishers won't do that. So that is a prescribed topic, and then the Vice Chancellor Rao Sahab will take a decision that we will publish that, convert that physical book into software copy and provide that to students. So they need not take any permission or license, no consent, no compensation needed, or royalties need to be paid.
Having said
So
that, Dr.
these
Raghavendra,
yeah,
see, in the Indian creative industry, if you really look at it,
yeah,
the rate of registration is very, very low compared to foreign jurisdiction.
I'm coming to that. I'm
Even
coming.
though this is a self-generating right,
Yeah.
but you think there are more benefits for formal registrations?
I'm coming to that. I'm coming to that. So basically, the copyright. Now let's take the example of Professor Anindya Sarkar. He has written a book on introduction to intellectual property law, and get it published by a publisher, famous publisher, Eastern Book Depot. Let us say that. So what are the rights come to that? Whether registration, after registration only Professor Anindya get the rights. So if you see the entire international copyright system, registration is not mandatory. So copyright is automatic. The moment you write a book, originality is must. So you just can't copy and paste. Nowadays, Chat GPT is what the generative AI is doing. It is simply collecting information without consent and not even giving a citation. That is high-tech plagiarism and also infringement. That's what the artificial intelligence generated to AI-based Chat GPT is doing. So that kind of work cannot be registered. When you register a book in a copyright office, it has to be a original book. So undertaking is given that it is a original creation, original expression. So what are the benefits of registration then? If registration is not mandatory, there is no formality. Clearly, one of the pillars of the minimum standards of Berne Convention is no formalities, no registration needed. Berne is included in the Article 9.1 of the TRIPS agreement. Again, TRIPS also says no registration is needed. Again, Article 2 of the WCT again repeats that all the Berne Convention Article 1 to 21 is inclusive of the copyright treaty, WIPO copyright treaty in the internet environment. Again, registration is not needed. Then why India has a copyright office? Why United States of America has a copyright office, or UK or China or Japan? Out of 192 WIPO member states, more than 50 countries only have copyright office. Why? Because registering copyright ensures that in case of any piracy, especially not only the physical piracy in earlier days, now internet piracy has become a big problem. Without your authorization, in unauthorized manner, many unscrupulous people digitize your work and upload over internet and various platforms, or peer-to-peer sharing happens. So easy way is to stop this. Go and register your work. So registration, that's what the section Copyright Office clearly mentioned the creation of Copyright Office mentioned in the Act, and there is a registrar and deputy registrar. There is a register. Register is not a physical register; it's a digital register where entries are made. And I introduced e-filing facility in 2013, so that those who has to apply for the registration? Only interested people. Who are the interested people? Let us say the author, that is Professor Anindya Sarkar. But author, what he has done, he has transferred all the rights in a contract agreement to the Eastern Book Depot. Then Eastern Book Depot become the copyright owner for the life of the author plus 60 years. So because Professor Anindya has transferred these rights to Eastern Book Depot, then who will file the application? Copyright owner has to file the application. Now, even though first owner of the copyright, that's what the section 17 subsection 1 says, who is the first owner? Both Anindya Sarkar and the Eastern Book Depot get doubt who has to file, who is the first owner. Professor Anindya Sarkar is always the first owner of the copyright because he is the author. It is his expression, his skill, his judgment, the originality. What is the originality in the same Eastern Book Depot versus D.B. Moda case? Supreme Court, while analyzing the originality, earlier days it used to be labor, skill, and judgment, sweat of both theory. But that common law concept has been put into dustbin by both U.S. Supreme Court and the Supreme Court of Canada. In the Fierce Publications and Ruler Telephone case, US Supreme Court said that this labor theory is old one, is a low level of testing the originality. There should be minimum degree of creativity. Then it rejected the copyright for the yellow pages. And what does yellow pages has? Only telephone numbers, addresses, and names. And there is no minimum degree of creativity. There is no originality. It's simply compilation. Where is this originality is described in international conventions? So Berne Convention Article 2, while describing the literary work, says it doesn't use the originality. It says selection and arrangement of the material in any form and any manner. So that's what selection and arrangement of one person who does, another person does, differs. So that is the originality that recognized legally. And then it says minimum degree of creativity. It's similarly, Canadian Supreme Court said, no, there should be a modicum of creativity. They set the high originality standard in such a high that they also, put this labor skill judgment in the dustbin. Whereas Supreme Court of India, while examining the originality of this work, they said Supreme Court cases, now the copyright belongs to Supreme Court only, but all the cases of the judgment they put in the website, anyone can make a copy edited judgment, give comments and executive summary and other explanations. But whatever the additional work who are doing, just like Eastern Book Depot does in SEC Online, copy editing the entire 1095 page judgment of Ayodhya judgment into simple 50 or 75 pages with a opening note, introduction, executive summary, and giving comments, on wherever it is needed, and concluding portion explanation. So this cannot be copied. That's what I said.
See,
Supreme Court judgment, it is copied anyone. Then why registration needed when you go? So registration, the copyright owner only Eastern Book Depot. If Anindya Sarkar has transferred the right. So yeah, give you example of Chetan Bhagat. Chetan Bhagat writes all the books, but he won't transfer the copyright. He keeps the copyright with him. In that case, if Anindya Sarkar is giving only license to publish, he is not assigning the rights. Assigning means transferring the rights, but keeping the rights only economic license is given, commercial license to publish to them. Then Eastern Book Depot still has to say that copyrights are with Anindya Sarkar only. I have license to publish, and he has to take no objection from him for registration of this book. And that is the registration. After registration, one certificate is given. So it is very easy to enforce this because Anindya Sarkar or the publisher Eastern Book Depot rush to any police station, file an FIR, a sub-inspector or who are sitting there what under ये copyright क्या है, तो proof दिखाओ, वो दिखाओ. So all these headaches will go. But without registration also, one can get the right automatic. I tell you, best example of the Kapil Chopra case of the Vishesh film. Kapil Chopra's script was copied by the Vishesh films, and they made a Jannat 2 film. When the matter went to the Mumbai High Court, the Chief Justice Shah and another judge, Jamdar, wrote that greed and deceit are the two characteristics on which Bollywood films are made. This film and piracy and misappropriation of script also starts with this greed. So he did not register. So still he could enforce the rights and get his 20,000 remuneration from the court when Vishesh Films, Mukesh Bhatt and Mahesh Bhatt were denying his rights. Then the new
So
technology started.
let us keep some of the answer little short and crisp so that we can look
Yeah,
at all the
sure.
questions.
I'm coming to the
See, since most, since more, we have a large background of participants who are students,
yeah.
and from the academic background, so let's cover a little more questions rather than getting very details into all those, which we can hope.
Let me go through questions one by one now.
I will tell
The next
you.
important question is
See,
the public performance. There was a question lightly.
just a minute, just a minute. See, there is always a debate between public access and private rights. Okay,
Yeah.
And we have had the Delhi High Court case also.
Yeah.
Now, students and academicians, many academicians also,
Yeah.
are dependent on many online databases.
Yeah.
Like LibGen, SkyHub, which they go to get resources, scientific literature or other academic literature, which is otherwise very, very expensive to procure. No, now there is no balance in this aspect. First of all, this is a violation of the legal right of the publisher. Okay, so if if you want to say how to strike a balance between this public access and private rights, because at one point these are uh, available by online databases and students and the academic community do access it, but this is also a violation of the rights of the publisher.
Yes.
What is your thought on the balance on this?
Balance entire copyright law or intellectual property right law balances not only the right owner's interest, also the public interest. Public interest, for example, you already said the education sector, research and teaching and students, everyone comes. The Article 7 and Article 8 of the TRIPS agreement clearly mentions this. And then based on that only the exception limitations concept has come. So there are 2-3 concepts. US follows the fair use concept in their section 107 of the US Copyright Act. And that is an open-ended thing where the four-factor test has to be put as per the Folsom versus Marshall Supreme Court judgment, that any exception, even for the educational purpose, the other research purpose, the universities, classroom teaching or research, uh, and you have students writing exams, all these activities, educational activities. What is the purpose of this exception given to education or research? What is the character of the exception? What is the amount of this thing used for this exception? Then finally, what is the impact of this exception on the owner of the copyright or author of copyright, commercially impacting that or not? Then when this four-factor test passed, okay, it is allowed. That's what they said. Since it is open-ended, all these new technologies. So one important thing they talk about the transformative thingness. Whether when you're creating a work, what is the transformativeness there? Means you're collecting information and creating a course package for the student. There is a transformativeness is there, means little originality the way you have selected and presented. So, and that too for this purpose, it's not infringement of copyright. Similarly, the generative AI. No, you might say you might use now artificial intelligence generative AI things either for creating course packages or students writing their course projects or research papers, etc. The problem here is, there is no consent in taking the information, collecting the information, and segregating the information, making a clusters, and finally providing you the end product. Because they are not taking consent, because in public domain, three kinds of information is there. Because exception, Professor Anidya, even for the educational purpose, the exception only from the legal access. Because other day one IP teacher was talking about, I can download a film and show it to students. Because you can arrange entertainment program for students, you can show a film. But if the audience is a paid audience, that is infringement of copyright. You can make the film artist come and do performance and start singing for your annual function of Nalsar University. Then it's free for the entire your faculty, researcher, and students and their families. But the moment you ask them, you pay minimum 50 rupees for the entry fees, and then that becomes a commercialization. You need to take a license. So that is the difference. So if you are, but you can't download something from a pirated website. So whatever, if you see the Berne Convention provision of Article 9, reproduction right, and Article 10, which gives various exceptions for the education, research, using quotations, etc., which is again incorporated in WCT and TRIPS, wherever the access and during entire Marrakesh negotiations for access to published works for the visually impaired, it is to focus on legal access only.
See, when you
Any
again,
parental thing cannot be
when
done.
you again
And
look
another
into
problem
this,
of Chat GPT is it might write 200 words project report, but it doesn't give any reference and citing. That is a high-tech plagiarism that cannot be accepted.
no, but
And
at that point, there are countries which have started releasing guidelines and official statements on generative
yes,
AI.
yeah,
See, Indian IP office till now is silent on this matter. If you look at US, Canada, Australia, they've come up with
yes, yes,
guidelines
yes,
how to use generative AI and what can be the how copyright can be looked into it. As I understand, most of this are classified as performance enhancers. Okay, not really copyright owners. So,
yeah.
what do you think should be the stand on this area from the Indian IP offices? See, going forward, such generative AI use is going to increase only.
Yes. Actually, what I see, Professor Anindya, the present Copyright Act completely protects any work. Any work means whether physical work or the soft copies of that work, or any literary, artistic, dramatic, cinematograph, sound recording, and performances, including computer program. This is the definite meaning of that any work. Even in emerging technologies, let us take the generative AI thing. Unfortunately, we have not addressed this issue. I agree with you, but Europe has come out with the guidelines, and US Copyright Office have at least 2 or 3 meetings with the stakeholders every week. And recently, last week only, I'm going to the Japan. Already, if you remember, and somewhere elsewhere, I've written that I subscribe to the decision taken by the Japanese government that AI learning, the whatever machine learning or learning mechanism they use, when you prompt a question to the generative AI chat GPT, you prepare this, you give me this, and all that, it comes out. So how it comes out? First, it does learning through the systematic learning, unsystematic learning, where systematic means where the entire material is labeled and systematically arranged, and other is unlabeled, unsystematic content available over internet, whether it is copyright protected or the public domain material out of copyright material. The third category is the pirated material. Three kinds of material available on internet. Whichever thing it is collecting information, learning, understanding, and writing an article for you, or writing a fiction like Chetan Bhagat, or like Shakespeare, or writing a poem like Ravindranath Tagore. It is doing the learning. So whatever it is coming out, it is a derivative work. I agree with uh, the entire American Authors Association that no transformative exception can be provided. Even iota of transformation is not there, because it is a derivative work. If you see the definition of adaptation in India, explain derivative work. So from literary to dramatic, dramatic to literary, from literary to artistic, artistic to literary. And best exam is a derivative work, creating a film from a novel. So everywhere you need to take consent. There should be a contract agreement, and compensation has to be decided. You have to pay royalties, some amount in advance, or once the derivative work is produced and put in the public domain. These are not happening. What Japanese office said that as long as it is doing the learning, the moment you put a prompt question to ChatGPT, it is collecting information. It has loaded inside the server or whatever. That is not infringement of copyright, because that is correct. That is clearly written in WCT. WCT said, what is the reproduction? Anything copied and digitized, stored in the computer medium, that is a reproduction. No, you scan a book, that is a reproduction. But it is lying in the computer database. And also, you go and search about 10 websites. So transient and incidental copying is done. Next time you log on, open that, and it automatically it comes. It won't start buffering away, because already it is stored in the computer. All these things are not infringement of copyright. That's what in the 2012 amendment, section 52(1)(c), we have clearly made it clear. It is applicable to artificial intelligence learning also. But what happens when it is infringement? If end product comes out, then it is no citation is given, no referencing. You simply ask a question to ChatGPT. Please prepare 1,000-word article on any topic. It within seconds it will churn out that 1,000-word article, and not a single citation. And you put a question again. Please start giving citation to give citation wherever possible. After buffering, it comes out with hardly one citation. If we are all researchers, when we go and see that it is insufficient. 1,000 words cannot be written with one citation. There must be multiple citations. So that infringement is coming. That is not clearly explained. That need to be explained. A kind of guidelines are to be issued. Hopefully, in my next meeting with the DPIIT officials, not virtually but physically, I'm going to suggest this. Maybe a committee they have to appoint, like people like you and other professors, taking initiative, giving a first draft and discussing what are the issues need to be covered. They have to start. That's what the American copyright have started, and EU is far ahead. And then what happens? Books published by this ChatGPT, because that is infringement. Books have been published without citation and also collecting information without content. Remember when I wrote an article on the origin and development of moral rights for the Journal of Intellectual Property Law and Practice of the Oxford University Press? They said, if you are using long quotation, more than 2 or 3 lines, and whether you're doing paraphrasing or not paraphrasing, more than that, you need to take copyright permission. You can't put pages together, cut paste and say give quotation and give citation. It is infringement of copyright. That is your headache. They have clearly said. So copyright is clear. You read any Indian act or UK or American or EU acts, all the international conventions only protecting. Only thing is interpreting and implementing how to protect this. Because one thing I always say, generative AI or any AI, only a general purpose assisting technology. It cannot replace us, number one. Then don't try to put spirit in that, because it is autonomously writing an article. No, it is autonomously writing, but infringing the copyright. Without the consent, it is collecting the information, and without citation, it is writing. It may be original language, it may be writing, but the entire idea is collected and reproduce. So that cannot become, you don't put a life into that. The Stephen Thaler applied for a copyright of the Rembrandt painting created by the generative AI, but the doubles later the standard diffusion or Mid Journey, these are the generative AI. They created music mimicking the voice and style of the singer, famous singer. So what happens to this? I say that it is simply an adaptation, a derivative work. They need to take a permission. They can't sell, Balasubramaniam voice or Shreya Ghoshal or Sonu Nigam voice style mimicked and imitated by the generative AI. Started songs, creating that songs and including in the new films, are selling over the internet. That cannot be happen without permission. And there is a concept we introduced in 2012. Section 31, there is a version recording is there. So all this comes under version recording, because version recording means the original singer is not singing, somebody else is singing the same lyrics, same music. Or even you are singing the new song, new music, but voice is the same. Sonu Nigam voice only, style is only his only. So this is learning. So I want to tell you that artificial intelligence, I put many ChatGPT tests. It gives you information which has been digitized, available in internet networks or even a computer database. Something, any book which is not digitized, it's lying in Nalsar library, it can't read. Simple. Any document lying on Professor Anindya Sarkar table or Professor Rao Krishnadev Rao table, which has not been digitized, ChatGPT can't write. So that article or a book is not complete, insufficient, because a lot of information lying in physical format. Then whatever it is collecting, it is not complete. I've put many tests in that. Either they give incomplete information or false information. Recently, I posted in social media, the young American lawyer filed an affidavit in the court. That affidavit was written by ChatGPT. The ChatGPT, in creating that affidavit, writing that, used 6 cases, and how it is relevant lodging in application of that legal problem. ChatGPT explained. This fellow, without facts checking that whether these 6 judgment are given by that particular court or not, he filed a case in the district court, and that smart judge sitting there, he has read all entire his petition, and to his shock, he said, "I'm shocked. Nowhere in the world these judgments, 6 judgments quoted by you exist. From where you got that? These are all bogus cases you have written. Bogus, the decisions, bogus ratio you was explained. So this cannot be accepted. This is illegal. I can take action on you." Then immediately, "Sir, forgive me. It has been drafted by ChatGPT without fact checking." Submitted. That guy is in trouble now. So don't put life into
That
generative
actually goes.
AI, start treating like that, and try to give rights to it, because the rights have to be with what Indian Copyright Act says. You simply read Section 2 definition. C, artistic work. A small 6, it says the rights, the author of the computer generated works. It's all computer generated work is the person behind the computer. That's what the even UK copyright officer and US copyright officer rejecting it. It is computer generated, AI generated work. Simply said, you are given a prompt, you have typed out your question, then only it has come out with a article or a book, or you are given a voice prompt, then only it has come out. And then how can it be author? and it is mimicking the songs of Sonu Nigam and Mohammad Rafi, how it is the original singer. Then
The
these
debate
are the
might not
problems.
be of the originality that they get sold as remixes and all.
Yeah.
But at this point, we reach a very critical thing which you are being mentioning, that is permission. One
Yeah.
should take permission. Now, when it comes to permission, there are certain exceptions on private use and certain distinction between public use. Now that most of this data is getting digitized, and with digitization, there is a huge emphasis on DRM, digital right management. Now, if you really look at it, except a few, big corporate sector, DRM regime is not very strong yet in our country. Okay, there are the big corporates who are very strong on protecting their data, so they have different layers of access for their data. So when you talk about the Indian copyright regime, there is a push or an impulse required to improve DRM everywhere. What is your view on that?
Yeah, if you remember, India included circumvention the provisions, legal protection, adequate protection for these devices, use of these devices, encryption devices, you call it digital right management, that are technological protection measures or rights management information. Section 65A, Section 65B we introduced in the Copyright Amendment 2012. We have said that any act knowingly removing these, I mean, hacking, that knowing that it is infringement of copyright, hacking and downloading the video or a song or a book or an article without permission, without logging in and without password, without subscribing it to it and paying some fee. That's what the Netflix we enjoyed during the COVID times. We all were sitting on home. We watch Amazon Prime or Netflix after taking a subscription for monthly 500 rupees or 200 rupees, whatever. So we have not done the breaking of DRM. DRM is being used, and the entire film sector, some extent, the piracy has been contained because of the use of DRM. That is the fingerprinting, or they're using a watermarking, they're using a now that. But uh, problem is now the AI going to create a lot of problems. No, you must have seen many times. You want to read one article available on the Google. The moment you go, you say that you only subscribers allowed to read. Subscription amount, you don't want to subscribe, but you want to read only one article. Let us say they allow you to pay 100 rupees and allow you to read articles. That facility also there. And what will you do? You can't copy paste it, you can't download it, because everything is restricted by DRMs. DRMs are not being used, but generative AI is giving a problem. So you are an intelligent man. There are generative AI websites. I don't want to give those names here to create problem for the right owners, that they allow you avoid subscription and download. This is the dangerous trend started by artificial intelligence, generative AI. And then you just take the mobile, even the article is available to you. You want to do some cut paste thing and quote in an article and paraphrase using a tool, but you can't cut paste because it is read only. What happens if you go to your mobile? There is a text extraction app is there. Text extraction, it is a algorithm. It extracts the read only text, okay, which is not allowed to cut and paste or copy and paste. It will extract a number of pages. You can do that. So whatever DRMs are put, this need are being violated without hacking it. Or this may be a kind of hacking done by the artificial intelligence apps and AI apps available over internet and mobile also. All these things are dangerous to the right owners' survival Of course, access to information has to be legally, lawfully, even for education purposes. But some exceptions were given to DRM only for the research education purposes. For example, you subscribe one journal of the intellectual property rights, you want to give it to all students. If it doesn't, your library wants to share it to the students, internet facility only, not downloadable, only read only. Even that is not allowed. What is the fun? Only one student can read at one time. Multiple students in multiple sites can't watch it, even though they are subscribed to your library website. Then DRM has to be broken. That is allowed in the copyright exceptions. That's what even the Article 10 of the exceptions to the WIPO copyright treaty, which introduced the DRM provision in Articles 11 and 16, said the member states can devise new limitations and exceptions to this, uh, which satisfy the three-step test. Only certain cases it does not conflict with the commercial exploitation of the work or does not prejudice with the author's interest. That's what with following this only we are given that university libraries can break DRM for education and research purposes, but they have to be careful not spreading these copies freely over the internet.
So, having said that, I think, my last question to you would be that, see, with different technological concepts, in this creative world, there has been a lot of increase in NFTs, non-fungible tokens. Now, what's your understanding that on extending a copyright protection for NFTs?
NFT is a beautiful thing happened, Anidya. During the lockdown conditions, we were locked down, sitting in our homes, talking like this to WebEx or Zoom, and only senior civil servants and like us wearing mask and the face sheet, going to office and sitting and working. Those dangerous conditions, and all your friends and relatives were dying. I lost my 10 of my relatives and friends during the phase 2 of the
Not a
COVID.
single family
Some
was spared.
beautiful minds created NFTs, non-fungible tokens, during that dangerous times. It's called COVID baby, I call it. So what is non-fungible tokens? Is basically they worked on the fungible tokens, that is the digital currency, the bitcoins. Bitcoin is based on the blockchain technology where entries are made in each block, extended from one block to one block, which are immutable. Once the data is put there, you can't delete it. The latest revised data has to be entered in the next block where time. So based on the time stamping, one comes to know, okay, yesterday Professor Anidya Sarkar put this information in this block. Now you want to delete because there is some change of information. You want to update that information. You can't delete it. You have to enter it in another block where today's time stamping is done. So this kind of transparency is there. This was introduced for the accountancy, the general purpose digital account register. That's why the blockchain technology started. It was used for the bitcoins, now for the non-fungible tokens. Now, non-fungible tokens, what's happening here? These tokens are being created for the music purposes, literary works, underlying works, and everything. So when you are doing this, even trademarks are also being done. Now, here, when you are preparing an NFT, there's a big thing over the internet. You must have read. Some intelligent guy created posters using the Amitabh Bachchan face, NFTs on that. He announced internet sale of his Amitabh Bachchan poster. He created NFT art on that. Immediately, Amitabh Bachchan office had to send a legal notice to stop it. We are commercializing this where you have not taken consent, not paying any compensation in that. So the sale was stopped. So it is clear that the existing copyright principles: reproduction, distribution, and also the infringement. Everything is covered, extended to NFT, non-fungible tokens as well. And even the contracts, soft contracts happen there. Problem is that Indian Act section 18 clearly mentions, which I taken and put it in the article 12, transfer of rights for the Beijing Performance Treaty, where I use the same concept of right to receive royalties for the authors, music composers, singers, which we introduced in the Copyright Amendment 2012. Same thing, we were so fresh with that idea, and then took it and exported it in the Beijing Treaty. So all these things are there. It has to be in writing in the contract. So it has to be writing, and sign has to be there. If not physical sign, digital signature has to, everything is stamped there. So similarly, not only the NFT, the metaverse, the another thing is happening. Again, in metaverse, the platform is centralized metaverse, where you create a platform, you allow all your students go and play there. The the augmented and virtual technology realities happening there. Then what happened? They are controlled by you. But the another thing is, decentralized metaverse is there. There anyone can go, anyone create. For example, decentralized metaverse platform using a kind of Mahabharata story like that. I can go and create one Ratha. I'm mimicking Krishna, and my son is working like Arjuna. That kind of thing I can create. Mahabharata war is happening. My chariot is running beside. I'm fighting for the Pandavas. So that kind of imaginary things may happen in a metaverse. But while in doing so, which art I'm copying? Very public domain means out of copyright information I'm collecting, creating these characters. I'm using the existing characters, whether I need permissions, any trademark violation I'm doing, or copyright drawing copied where copyright exists, or I'm putting any music there in which copyright exists, or a film clip I'm using there, copyright subsists. These are the things have to be said. So all the online network copyright things, which has been included in the WIPO Copyright Treaty, WIPO Performers Phonograms Treaty, Beijing Audiovisual Treaty, the minimum standards of all treaties incorporated in Copyright Amendment Act 2012 exist, can be applied 100% to NFTs, non-fungible token artworks, also the metaverse. Simple. We don't need any new law to address these things. I always say no need for the new law at present, even for the artificial intelligence, chat GPT, or any generative AI, because totally they are doing infringement or plagiarism. Infringement is a legal construct. Plagiarism is a moral construct, ethical construct. People talk about so many ethics. One law teacher was talking about, where are the ethics, morals? It is the original expression of a artificial intelligence. How can you say you are an author? Then he said two things. It can't be given author similar to human beings because it is a machine. And even though you can't call it the created by the work originality, because it is collecting information from already existing works, or public domain works, or pirated works. Then last one thing, I'll stop with the moral rights. Economic rights I'm not applying. Can moral rights can be applied? When a chat GPT starts writing a poem like Rabindranath Tagore, Gurudev Rabindranath Tagore, the first Indian who got the award, Nobel Prize. It writes a poem similar to him. Now Rabindranath Tagore is not alive. No, a book has come out of poems of Rabindranath Tagore. Everyone start research in.
I think he got
Book
disconnected.
of poems in this century. But you see, what is the moral right? The best thing is second moral right is it is violating the paternity, because it is not Rabindranath Tagore has written, it is ChatGPT has written. That is a violation using his name attribution. Number two, right to integrity and respect means it is the honor and reputation of the author. It comes from, in the beautiful case in Amarnath Shegil case or other cases, Supreme Court said equal the moral rights with the fundamental human rights, because look at as a boy he has grown up, he learned many things in the Bhadralok social system, his family, and his entire relatives. Father was a great artist or intellectuals that came into his genes and learning mechanisms. And there was the Raja Ram Mohan Roy's movement was there. There were several movements were there. Ishwar Chandra Vidyasagar and all that impacted him. And he was, he was not a leftist or a woke. He's a very religious and spiritual person. Look at his Gitanjali, entire spiritual thing. My leftist woke friends in my college, Usmania University, Hyderabad, they used to hate Gitanjali because it is the description of spirituality and God, entire the philosophy of Upanishads there. So it is his learning. The learning of the Gurudev cannot be compared with the learning of a machine learning or a ChatGPT, which does in few seconds. So no moral rights also be granted. Thank you.
I think you have explained it very, very, very simply for all of us. Friends, with this, we will come to the closure of today's event. I would like to thank Dr. Raghavendra Garu for spending his time and really addressing issues which are so pertinent in today's digital world. Uh, I would also thank our Honorable VC sir for allowing us and encouraging us to hold such programs and events. This program was brought to you by the host by NC Banerjee Center of IPR Studies and DPIIT IPR Chair. Both are from Nalsar. I'm also thankful to all the participants. We've got some wonderful comments and so relevant, which would help many of us to continue thinking in this line. And I'm sure we'll be back soon with similar programs and similar events on a regular basis. Thank you all for taking your time out and joining us. Okay.
Thank
Have a
you,
wonderful
Professor
day.
Anindya and Professor Krishnadev Rao Garu and all other faculty members and students. Jai Hind. See you again in future. Thank you.
Thank you very much. Have a wonderful day.